Good afternoon, ma'am.
Afternoon. Are you comfortable?
Yes,
अपने बारे में कुछ बताएं.
I'm Priya and I live in Delhi. I did my law from Symbiosis, Noida. Last year, I did my LLM from NLU Shimla. I have been practicing since, and I recently joined as an LR in Delhi.
Why did you choose judiciary only for your career?
I felt that my persona and my beliefs were more inclined towards the bench rather than the bar. Though I enjoy litigation as well, and litigation is what makes the legal profession so proactive and profound. However, I felt that my personal beliefs and my inclination was towards judicial.
अभी अभी आपने हरियाणा का आप इंटरव्यू दे रहे हैं, लेकिन अभी दिल्ली का भी रिजल्ट आ चुका है. उसमें भी आपने मेंस क्लियर कर लिया, तो आप का इंटरव्यू भी है. अब दिल्ली का मेंस हो गया तो दिल्ली का इंटरव्यू भी आएगा, तो आप कौन सी स्टेट को प्रेफर करेंगे? हमारी तो हरियाणा की एक सीट वेस्ट हो जाएगी अगर हम आपको देते हैं, तो हमारी एक सीट खराब हो जाएगी. आप कौन सी स्टेट ज्यादा चुनेंगे, दिल्ली को चुनेंगे या हरियाणा को चुनेंगे?
Whatever result comes first, I will give my poll to that state, because I understand that if I appear for another interview and I would be taking away an opportunity from a person who would want to join that service, but I would take that seat instead, having qualified for both. So I will make up my mind prior to that.
So, I would like to ask that if we talk about section 479 of Bharatiya Nagrik Suraksha Sangha, have you gone through BNSS?
Yes.
Okay. So, that's the replacement of the Code of Criminal Procedure. So, what would be the fate of 479? Would it apply retrospectively for the under trial persons across the country or not?
As per the recent decision of the Honorable Supreme Court, in the case of inhumane conditions in 1382 prisons, the Honorable Supreme Court has held that Section 479, if I am not mistaken, Section 479 of the Bharatiya Nagrik Suraksha Samhita would apply retrospectively, being a beneficial provision, and it has reduced, in certain cases it has reduced the period of detention from 1/2 to 1/3 of the maximum punishment, and hence it would be applicable retrospectively as well.
Okay, so if you clear this interview, if you crack this interview, you will be posted at judicial magistrate. Suppose you are posted as judicial magistrate. And accused first time talks with the judge for the trial, and accused informs you that he was coerced to tell his own password, his cell phone's password, by the police during the investigation process. How would you proceed?
Ma'am, during this period, I understand that the right of privacy of an accused person has also to be taken care of by the judiciary, and considering the right to privacy as a fundamental right, I would balance the investigative powers of the police with the right to privacy of the accused, and I would inquire with the investigation officer as to whether the phone or whatever device's password that has been taken by the investigation agency is in possession of the investigation agency presently or not. If it is, according to the judgments of the Honorable Supreme Court and various high courts in this regard, the due process is followed, and only that material is taken or extracted or copied from that device, whatever is material for the present. not incriminatory. However, we have to respect the right to privacy of the
Okay. Acha, tell me another thing. Suppose that there is a case of voyeurism. Accused persons have recorded the videos of a victim during she was taking a bath, and this was happening on a mass level. And the accused persons have uploaded the videos on iCloud account. Would then, if the victim asks for the password of accused so that she can delete the videos or whatsoever material there is that posted, can we allow victim to give password? Can we allow accused to give password to the victim? Password to be given to the victim?
If I consider, I'm not aware of judicial decision on this. However, in my consideration, should not be granted the password of the investigative authorities might be given access to that. So in order to delete those videos, and a direction be passed on the websites to which on which such videos are uploaded for them to remove them from their servers. And by this, the rights of both the accused and the victim would be balanced.
Tell any 5 random changes which have been incorporated in BNSS as compared to CRPC, if you are aware about BNSS. Any 5? Yes, sure.
Can I take a moment?
Yes, sure.
First would be, as you pointed out, Section 479 of the
Yes,
BNSS, which changes the maximum punishment detention period from half to 1/3. Second would be that in complaint proceedings, in case of a public servant, a notice has to be given to both the public servant as well as the superior of the public servant before cognizance is taken. And in other cases, notice has to be given to the person himself before taking of cognizance. I'm unable to read that.
It's okay. It's okay. BNSS provides about audio and video electronic means for recording the deposition of witnesses, which means that we can also take the testimony, that we can take the deposition of witnesses through video recording or any electronic means like video conferencing, etc. Whether police stations can be designated as place for audio video electronic means for the examination of witness, whether state can designate police stations as place for the audio video electronic means examinations of the witnesses. I passed this.
Hi, Priya. I think you are enjoying this journey to occupy the chair of the judge. And I'm very impressed by your answers. You have very good command over the nuances of criminal law. I will read out section 531 of BNSS, particularly 531 subsection 2A. I don't want that you should have exact knowledge of the provision. I am not even expecting that you should have very good command over the case. I just want your own view after going through the content of this BNSS. I will read it out for you. The code of CRPC 1973 is hereby repealed. Second part, notwithstanding such repeal, A, if immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial, inquiry, investigation pending. Appeal, application, inquiry, trial, investigation pending. Then such appeal application, trial, inquiry or investigation shall be disposed of, continued, held or made as the case may be in accordance with CRPC, as enforced immediately before the commencement, as if this Sanhita had not come into force. Now, we as a High Court, we are giving you first posting at Chandigarh only. The very first day, the very first case which you are going to handle, it is prior to 1/7/2020. It's a case of 325 of Indian Penal Code. But when you have joined, it was 1st October 2024. Prosecution has submitted before you, and you will also find it from the record, both available and non-available, it was to no avail. Whether the application under 82 or 83 CRPC would be maintainable, or the parallel provision in BNSS and the procedure now enacted in BSS, it would be applicable. And you can please, sir, madam, please pass on. You can go through the language because she has to handle it. You go through 531 2A.
A criminal court, and the proceedings have been initiated under the and the effect of this provision is that the BNSS would apply prospectively and not retrospectively, and the presently whatever is pending before the court must be continued to, as if the BNSS had not come into force, and CRPC would apply. So,
excellent, Priya. But please give attention to my proceeding was pending since 2002, that is prior to 1/7/2024. Definitely this proceeding will have to be disposed of as per CRPC, as per 5 with provision 21(2)(a). 531(2)(a). Very right. But my question was that a fresh application is preferred, but that is preferred under CRPC. My query to you is whether the prosecution is expected to exhaust remedy under 82-83 CRPC for initiating a proceeding for proclamation under the old code, or the new procedure for the person to be a proclaimed offender has to be exhausted, because it is entirely different now. The application is not pending, it is moved for the first time. 531 2A speaks about 5 things: inquiry, investigation, trial. It is an application, appeal no, it's an application. 5 में ये भी आ रहा है, और ये आ रहा है तो ये फ्रेश है, फ्रेश है तो क्या बोलते? Now this was held a day before. Punjab Haryana High Court has dealt with, but it has dealt with at appeal. Application से अभी तक there is no High Court, but this judgment has come a day before. Can you cite the judgment? Okay, no issue. But you are very right that at least even in a pending proceeding, some application is filed, unless and until it is taking some substantive right, it is safe to give it a plain interpretation. And as per plain interpretation, because the appeal was not pending, it is a fresh appeal. then the new BNSS provision would be applied. Very good. Next question.
Sir, I can recall two judgments right now. That is Jagjit Singh, which was related to the
You
rights
can keep the book on table, please. Be comfortable. Yes.
of the rights of the witnesses to participate in the proceedings before the court. Regarding vulnerable witnesses, I cannot recall this.
Okay. Some Padade, Bombardke, or something, Smriti Tukaram.
Smriti Tukaram.
Because I think it was tip of the tongue,
Yes.
but you okay. Earlier, there was confusion regarding how to calculate 60 days or 90 days whenever you have to deal with the matter of default bill, compulsory bill. My first question to you is whether the first day when the accused is produced before you is to be included or excluded for the purpose of computing either 60 or 90, whatever the case may be. Whether the first day before you would be calculated.
So it would have to be excluded as per the decision of the Honorable Supreme Court in Kapil Varfan versus CBI. It was held that the first day on which the accused is produced has to be included.
Included. Good. It has to be included because it is a pro-accuser.
Yes, yes.
Good. If for the initial 15 days, the accused before you made an excuse or maybe genuine cause, he remains admitted in the hospital. On the 16th day, the investigating officer has asked permission from you to send him in police custody so that you can associate the accused for disclosure statement for recovery of the knife as a weapon of offense which he has used for committing murder. Whether BNSS can be applied in that pending case prior to 1/7/2024?
Sir, BNSS brings a substantive change in law in this regard. The initial view under the CRPC was that the 15 days period was only from the first day of custody and cannot extend to the whole period of 60 or 90 days. However, under BNSS, the 15 days period can extend to various as regards various periods of time within the whole sphere of 60 or 90 days. So, in my regard, being a substantive change, it should not apply on the existing
Very good.
proceedings.
It will not apply. Again, we will take recourse to 531(2)(a). It says if the application is filed afresh post 1/7/2024, then only BNSS comes into operation. But here the application was filed prior to 1/7. You are dealing post 1/7, but then you cannot take BNSS and you cannot dwell into the matter. Because at that time the matter was pending before Honorable Supreme Court. There was conflicting judgments also. Can you name a few judgments which has dealt with that Anupam Kulkarni, which has tied the hands of the magistrate and therefore they cannot deal with beyond 15 days. At any circumstances they cannot. Howsoever the case may be severe, but the magistrate could not.
Yes.
But then Honorable Supreme Court said that Anupam Kulkarni needs a relook. Can you cite a few judgments where Honorable Supreme Court said like this?
So I am not able to recall that judgment, but I am aware that the Honorable Supreme Court took into their consideration that the fact that there are various cases in which the accused misuses the law and abuses the law so as to...
Brilliant. It was Vikas Misra and Central Bajaj. Excellent. Okay. Whether the principle of res judicata applies between co-defendants or co-plaintiffs?
Sir, it applies both on co-defendants as well as co-plaintiffs.
Very good.
It applies on co-defendants only where there is a conflict between the co-defendants in themselves.
Can you cite some example, practical example, or some, if you want, to clarify?
Sir, there may be a case as regards the
The first criteria was there has to be some conflict of interest between co-plaintiffs or co-defendant. Very right. Second criteria. I will help you. No issue. But because your first criteria was very important. Second was that without adjudicating the conflict of interest between co-plaintiffs or co-defendant, you cannot proceed further and you cannot adjudicate. Before you that without effectively adjudicating you cannot adjudicate the case between plaintiff and defendant. Then only the principle of res judicata could apply. Okay? Can you give the example?
Sir, when a person files a claim against two individuals, where the defendants are mother and son, as regards it deals with inheritance, right as to inheritance of a property, as well as the other person is claiming that he has been gifted the property.
Excellent. ठीक है, very good. You are doing good. Anything else?
So there may be a case where the co-defendants are lessee and sub-lessee of the property, and they have been impleaded by the plaintiff, who is the landlord, and the sub-lessee is claiming that he has been legally put into the possession of the property, while the lessor may be claiming otherwise.
Very good. Tell me, if in a case, on the bare reading of plaint, it appears that it is time bound, what are the various remedies available to you to dispose of it at the earliest?
So, order 7 to 11 can be applied, though it can only be applied at the application of the defendant. If the court feels that the plaint in itself shows that there is the suit is time barred, then in case by operation of section 3 of the Limitation Act, the court is empowered to dismiss this.
Brilliant, very good. But I just want to correct you that 7-11 can be initiated by court also. It holds that application is not moved by any other party. At any stage it can be exhausted. Very good. Okay. In Punjab, TPA has no applicability. And a party is saying that since TPA is not applicable, the principle of lis pendens under section 52 of TPA is also not applicable. What is your say and what Honorable Supreme Court says?
So, as regards section 52, which deals with the lis pendens, devolution of property during the pendency of a suit, the principle of section 52 is made applicable even in the states of Punjab and Haryana and Delhi, where considering the provisions of the TPA, it might not be strictly applicable, but the principle has to not render the judicial process to be ineffective, and we are subject the devolution of such property to the decision of the Honorable Court.
Very good. You just tell me, if in a case there is no substantial defense with the defendant, rather he either comes with categorical admission or evasive denial, what are the remedies available before you to dispose of the case?
Sir, in this case, in light of the provisions of Order 8 Rule 5 and Order 12 Rule 6, the court can take the view that since there is no denial or there is evasive denial, it will be deemed as a it will be deemed admission by the defendant, and considering that, the court can pass a judgment in it.
Very good. Whether admission is a conclusive proof?
So it cannot be considered a conclusive proof, though it can apply as estoppel.
Excellent. Can you cite me the provisions from Indian Evidence Act 1872, which says that admission creates estoppel, but it is not a conclusive proof?
Section 31.
Excellent.
Indian Evidence.
Read with. Where is it defined? Admission is defined under section
17.
17. Read with 51. You have spoken about Order 8, Rule 4 and 5. Read with Order 12, Rule 6. Can you remind some provision under Evidence Act where Order 8, Rule 5, the deemed admission in the pleading is also given place in the Indian Evidence Act?
Deemed admission.
In the pleading, deemed admission. 58 of Indian Evidence Act directly deals with this. Can you recollect? 17, 31, 58, 70. These are 4 provisions under Indian Evidence Act dealing with admission. Okay. You tell me, what is anticipatory bail and transit anticipatory bail?
So, anticipatory bail is when a person is apprehending his arrest by the authorities, and he approaches the court and he conveys to the court that there is some apprehension as regards a particular set of circumstances and particular offense as regards which he is apprehending arrest by the authorities. The effect of such anticipatory bail application is that it converts a non-bailable offense into a bailable offense. It does not bar the authorities from arresting a person, but it allows him the right to bail as soon as he is arrested by the authorities. And as regards transit anticipatory bail, it has been clarified by the Honorable Supreme Court in Priya and Doria case, where the person is in the jurisdiction of courts which are other than the place where the FIR has been filed or apprehended to be filed. Then in such cases, the person can approach the appropriate court for asking for transit anticipatory bail.
Brilliant. Very good. Suppose you are posted at Gujrat, Haryana. Your SHO inadvertently conducted an investigation pertaining to density, and he has produced that challan before you. What is your duty as a magistrate?
Sir, in such cases, the investigation would not be vitiated, considering that there is a provision under the CRPC which states so. However, I would not be the appropriate court for considering the jurisdiction, and I would transfer the same to the appropriate court.
Where is the power provided to the magistrate to transfer?
So I'm not able to take.
Magistrate is not vested to the powers of transfer. At the most he can make over, at the most he can forward, at the most he can commit, but he cannot transfer. Even 410 does not deal with that. It is misconstruction. But here it is not a case about transfer. It is a challan, charge sheet. Your SHO inadvertently committed a mistake. The case pertains to Delhi. He has investigated the entire case. He has made out a case, produced challan before you. How you will deal with it? What direction you can pass to your IO? You have rightly said it will not be vitiated. Now it is a perfect challan. The horse that some mistakes have been committed by your SHO. But then how you will deal? You cannot transfer. But then what you will do with that charge sheet? What direction you can pass to your IO?
So I can give it back.
Yes. First thing, second.
And then ask him to approach the appropriate.
Excellent. This is the rule. like we do in returning the plate. So we will hear, this is a judgment law. Honorable Supreme Court says, whenever you face this kind of situation, then don't bother about the challan. It is as legal as. And this mistake, it occurs when there is a man, there will be an error, but you will direct your SHO to file it before the court. Suppose, Priya, you have said about Priya and Dora, a case, brilliant case, transit anticipatory bail. Suppose in a given case, a girl from Shimla, she has married to a boy from Jhajjar. It was a love marriage. Boy was from Jhajjar, girl was from Shimla, but unfortunately, शादी निभी नहीं. और लड़की की ये ट्रेजेडी थी कि आपके पास आ गई और आप दिल्ली में ये बात बोलती है, तो क्या आप FIR लॉन्च करवा सकते हो 498A का दिल्ली में?
Sir, if the proceeding, if such circumstances or such instances occurred in Delhi only, then can an FIR be filed in Delhi? Otherwise, it would have to be filed in Haryana. However, proceedings under the Domestic Violence Act as regards maintenance as well as shared household or
Very true, very right.
Recall the exact.
Madam will tell you the name of the judgment where the girl has given extra jurisdiction in criminal cases. First of all, you cannot lodge the FIR because you don't have any locus standi under 498. You are not her relative. You are neither a public servant. It is a qualified cognizable offence. So at least you can advise your friend to lodge an FIR. But can you advise your friend to lodge the FIR even at Delhi? Yes or no? Ma'am?
There is a judgment of Rupali versus State. If your friend comes to you and asks, what should I do now? You can also advise her to lodge FIR in Delhi also. It has provided extra jurisdiction to the girls to lodge complaints.
And you can trace out the analogy also. Look, 498 explanation says even it covers mental cruelty. If a girl leaves Shimla or Jhajjar, her mental pain is also traveling with her even at Delhi. So it is a continuing cause. And that's why there is a brilliant
अभी आपके मैंने CV में देखा आप अनमैरिड हैं, तो आपकी मैरिज अगर हरियाणा में नहीं होती, उसके बाहर होती है, तो आप कैसे मैनेज करेंगे?
I take inspiration from the honorable justices that are there in our high courts as well as the honorable Supreme Court. My commitment towards the judiciary would not be undermined by any circumstance in my life, and I commit myself fully to it.
Okay.
Ma'am.
So I think we are done. Okay, so great interview. Thank you.